Moving on from that, then, the first thing that I'd say to you is we should always consider whether or not a client should have a statutory will. Essentially, how these work, upon sealing the will, the Court of Protection essentially says it has no peace signed it themselves in accordance with the Wills Act 1837. Section 9 doesn't officially apply, which says that the will has to be signed by the person, the testator, in the presence of two independent witnesses. It works slightly differently. What will then happen? The official solicitor will be appointed on behalf of P, and usually wills, things like this, where people are starting to lose out on inheritance, you will find that they will start objecting. It's funny that, isn't it? And you will generally end up at a hearing. It may be you have an application where everybody's in agreement. I have a particular case at the moment where this is the case. We have a half brother who wouldn't inherit, and it's upwards of £1 million at the moment. But he does more for his brother than the others do, and everybody gets on. They're all in agreement that actually half brother who wouldn't inherit on intestacy, the full bloods would. It's not like Harry Potter, don't they? But the full blood people do. They've all agreed that he should be treated in exactly the same way as them, and so we have got an application where everybody's in agreement. Please do take the time to read through your practice directions if you do need to remove trustees. The Society of Trusts and Estate Practitioners have developed two really, really good flowcharts for the appointment and removal of trustees, dependent on whether you're going down the High Court route or the Court of Protection route. And I'd recommend, if you are going to be doing this sort of work on a regular basis, I'd recommend downloading those from the Society of Trusts and Estate Practitioners. It's one of their, not so much a practice note, but a note on specifically the appointment and removal of trustees that they release, like a special release document. And if you pop it into Google, it should come up. I'd recommend using those because they are really good in pointing in the right direction of which one to use, because a lot of people just immediately go to section 36, and actually you might need some of these others.